We're going to discuss the nature and classes of contracts. A contract is a promise or set of promises for the breach of which the law gives a remedy. There are various elements of a contract. The agreement phase is the offer plus the acceptance, and it has to be between competent parties or parties that have contractual capacity. Also, there has to be a true agreement or genuine assent. The contract has to be, in order to have a contract, you have to have a benefit detriment on both sides, which means there has to be someone giving up something and that same person has to be getting something on both sides. Parties have to be giving up something and getting something. That's consideration. The contract has to be made for a lawful purpose. Contracts usually do not have to be in writing, but there are some types of contracts that do have to be in a specific form or have to be in writing. Those are contracts that fall within the statute of frauds, and we'll discuss that later. The subject matter of a contract can be about any legal purpose. It can range from personal service, employment contract, and also transfer ownership of property. In this area, we will be talking about common law contracts. We will be focusing on services and also the sale of land. We will not, for the most part, be talking about the sale of goods. That is governed by the Uniform Commercial Code, Article 2, which is a business law area. When you have a contract, the person who has the obligation to do something is the promisor, and they're also the obligor. A person who's getting the benefit of the promise is the promisee and also the obligee. For a contract, you will have both parties will be the promisor and also the promisee, and the obligor and the obligee. The parties to the contract are considered to be the only parties as a general rule who can sue. There are some exceptions. The parties to the contract are said to be in privity of contract, and the contract usually only binds the parties to the contract. In order to have a contract, you have to have a valid offer, and that valid offer has to be accepted. There has to be a serious contractual intent or intent to enter into the contract. Contracts can be classified as formal contracts versus informal contracts. Formal contracts include contracts that have seals on them, which are written contracts, obviously. Also includes negotiable agreements and negotiable instruments. And then it also includes contracts that are made in court or recognizant contracts or negotiable instruments we will talk about in business law or will be discussed in business law. But if it's not one of those three, it is considered to be an informal contract. An express contract is a contract where the agreement phase, the offer, and the acceptance are either shown through words or that are spoken or shown through words that are written. An implied contract is when the offer and the acceptance are not expressed through words but are shown through conduct, where it arises when a person renders services under which a reasonable person would expect that payment would be expected. A contract can be classified as to whether it is valid, voidable, or void. Valid is when it's binding and enforceable. Voidable is where there is a problem with the contract such that one party can get out of the contract. An example would be with a contract made with a minor. A minor usually can avoid or set aside a contract because it's voidable at the option of the minor, because minors tend to lack contractual capacity. They don't understand they're entering into a contract by law that is considered to protect minors. A agreement that is void is without any legal effect. So a agreement about engaging in a crime or an agreement that is a subject of a crime. For example, if you make an agreement to sell an illegal drug with someone, that agreement will be without any legal effect or will be void. Contracts can be classified as to whether they're completed or not. If the contract is completely performed or completely completed, it is an executed contract. If there's anything that remains to be done, it is an executory contract. If the offeror, who is the party that makes the offer, wants acceptance as a promise, it's a bilateral contract. If the offeror is looking for performance as acceptance, it's a unilateral contract. So, for example, if you have a reward situation, if, for example, my dog is lost and I give a reward to the person who finds the dog, a promise to find the dog is not what I'm looking for. I'm looking for actual performance. So, this is a unilateral contract where I would be the offerer in that example. I'm looking for performance as acceptance. If there is a no true agreement, the court may impose a quasi-contract to prevent an unjust enrichment. So it's when the court imposes a contract to prevent unfair circumstances would be when a quasi-contract would occur. But a quasi-contract is not needed if there is an agreement between the parties.